Welcome to Together for Justice, a tribal and state legal advocacy tool. This resource from the Native Alliance Against Violence, the Seminole Nation Domestic Violence Program, and the Oklahoma Access to Justice Foundation was created to equip advocates and survivors with plain language legal information and tools to navigate Oklahoma's complicated court landscape. In this video, we will take a closer look at the Oklahoma Survivors Act, who qualifies, how the process works, and what it can change. Domestic violence, sexual assault, and trafficking can trap survivors in cycles of fear, coercion, and control. Sometimes those circumstances lead to criminal charges when survivors act under threat or pressure. The Oklahoma Survivors Act, passed in 2024, directly responds to those realities. The act allows judges to reconsider a person's sentence when their offense was connected to experiences of abuse or trafficking. Judges can apply the act at 2 points: during the original sentencing or later through a resentencing hearing. The act does not erase a conviction, which is a separate process called expungement. Instead, it focuses on the sentence and ensures that punishment reflects the survivor's lived experience and the impact of the abuse. The Survivors Act applies to people convicted in Oklahoma State Court whose offense was connected to their experience of domestic violence, sexual abuse, or trafficking. A survivor may qualify if they experience domestic violence, sexual abuse, psychological abuse, or coercion as defined in the Act, and they can provide documentation showing the connection between the abuse and the crime. The law covers survivors who are currently incarcerated, on probation or community supervision, or being sentenced now. When someone is being sentenced, the judge must take a look at any proof of abuse when deciding the punishment. For people who are seeking resentencing, there is an extra step they must satisfy before filing an application. Survivors must submit a request to apply for resentencing to the court before they are eligible to apply. The process begins by a survivor or their attorney filing an application for post-conviction relief in the same court that issued the original sentence. And Oklahoma provides a template, Oklahoma Court of Criminal Appeals Form 13.11, which survivors can use to start the process. The written filing and documentation are critically important. The application must clearly describe the survivor's experience, explain how abuse contributed to the offense, and include required evidence such as police reports, protective orders, medical records, sworn statements, or counseling records. Strong documentation to support the application should be attached. Evidence can come in many forms, such as police or incident reports describing the violence, medical or counseling records that show treatment for trauma or injury, protective orders, court filings, or affidavits, testimony from experts or advocates who can explain the survivor's experience, or other written proof linking the abuse to the criminal act. Once a survivor submits an application, the case is sent to the judge who originally handled the sentencing, or to another judge in the same district if the original judge is no longer there. The judge then reads the application and any attached documents that were submitted to decide whether it meets the basic legal requirements to move forward. This first review is important because the case cannot continue unless the application is complete and includes the required evidence. If the application meets the requirements, the court schedules a sentencing hearing. At that hearing, the judge can listen to testimony, review written statements, and consider other evidence, including records from the Department of Corrections when relevant. After looking at everything, the judge will decide whether the survivor has shown, by clear and convincing evidence, that the abuse or coercion was a substantial contributing factor in the offense. Clear and convincing means the survivor has provided enough believable evidence to make the judge firmly believe the abuse played a major role. If that standard is met, the judge must reduce the sentence within the ranges set by the law. The judge then issues a written order explaining the decision and why it was made, and that order becomes part of the official court record. The Survivors Act offers an important pathway for survivors whose abuse influenced their criminal case, but it also has limits. Understanding those limits helps set clear expectations. The Act does not change or erase the underlying conviction. It does not remove a case from someone's criminal record, undo the judgment, or replace the conviction with a lesser charge. What the Act can do is adjust the sentence. A judge may reduce the number of years, change the type of punishment, or replace incarceration with community-based supervision or treatment. These changes can make a meaningful difference in a survivor's daily life and positively impact their safety, housing stability, and re-entry planning. Put plainly, the conviction stays the same, but the consequences of that conviction can change. The Oklahoma Survivors Act represents a major shift in how the state justice system treats people who have experienced domestic violence or sexual abuse. Although it's not an automatic guarantee of a reduced sentence, it opens a path to justice that wasn't available before. If you or someone you know may qualify for relief under this law, it is important to talk to an attorney or trusted advocate, understand your rights, and get help. Thank you for joining us for Together for Justice, Tribal and State Legal Tools for this quick introduction to the Oklahoma Survivors Act. Please join us for other videos in this series. This resource is for education and legal information purposes only and is not legal advice. Laws and remedies may vary between state and tribal courts. Advocates and survivors should consult with attorneys for case-specific guidance.